and they can use their invention for a period of 14 years. Then Patent and Design Production Act was coming to the force in the year 1872. Then the Production of a Invention Act was introduced in the year 1883. And finally, all these things are consolidated as a Invention and Design Act in the year 1888. And the Indian Patents and Design Act was established in the year 1911. And after independence, okay, after an approximately 25 years after an independence, Indian Patent Act was established. And that particular act was came into the force after 2 years of that implementations. From the 1972, the Patent Acts of India was come into the force. From that time, there is some amendment was introduced from time to time. In the year 1999, 2002, 2005, there are some amendments are introduced, and it was came into the force immediately. So these are all the major milestones in the history of Indian patents. So now coming to the major part, which invention I can get on a patent, and which invention I can't get a patent. So what are all the invention we can get a patent? Which are all those things will come under the patentable inventions? Okay, if you want to get on a patent, you can get a patent for either a product or on a process, or combinedly for both the product as well as on a process, you can get on a patent. But the product or process must satisfy these 3 criteria. It should be novel. There should be some inventive step, and that must have some industrial applications. So if your process or patent satisfy these 3 criteria, you can file a patent. So your thing should be a novel, and it should be have some inventive steps should be there, and that should be some industrial application. And another one thing, it should not fall under the section 3 and 4 of a Patent Act 1970. So what is that section 3 and 4, sir? The non-patentable invention. We are going to discuss elaborately about these section 3 and 4. Okay, it should not come under these 3 and 4 sections, but that should be a novel, and there should be some inventive step, and they must have some industrial application. Then we can get a patent for that particular process or on a product. We will discuss these 3 criteria elaborately one by one. Novel. What is that novel? Simply it means new. That means that particular invention should not be published, not only in India, in anywhere of the world. That particular invention, that is the first time. No one is still that published that particular product or on a process. And no one should have some knowledge about that particular process or on a patent. And there should be some exemptions. You can display your invention in public exhibitions, or you can present a paper before a land society. But only thing is what? If you presented a paper or if you displayed in public exhibitions, within a 12 months of a period, you should apply for a patent. If you are not applied within 12 months, that is 1 year, then you can't able to file a grant for your inventions. Okay, so because the most important thing is your work should not be published, and that one only we can get on a patent. But you can present your work in presence of for example, you are invented something and you are going to conferences and you are presenting. You can present it, but From that date, within a 12 months, within a 1 year, you need to file your patent applications. Inventive steps. So now if you are looking inventive steps, what is that indicates? Is there any advancement in the technique what you are used, or the most important thing, economic point of view? Okay, whether it is less than the available things. So some product is available. Compared to that particular product, if you produced on a same product with on a less cost, how you produced with on a less cost means because of that advancement in on a technology, then you can go get for your process patent. Or both the things. There will be a technical advancement as well as there will be an economical significance also. Then that indicates there will be an inventive steps. Okay, when the questions will arise, inventive steps, if your product or if your process is novel, if it is new, then only the question will arise, is there any inventive steps? And the most important thing, okay, you are inventing something. Because of that invention, there is no use. Then if you are getting on a patent, what's the benefit? Nothing. So what is the use of that invention? Because of that invention, is there any benefits to an industry? Or the most important thing is common people, public. Is there any benefits to a public or not? Okay. So when it is satisfied to all these things, then you can go get for a patent, but it should not come under section 3 and 4. That keep in mind that the coming slides we are going to discuss about that section 3 and 4 elaborate. And what are all the subject matters we can get on a patent? We can get a patent for any articles, or if you design any apparatus or any machineries or its components. So we can get on a patent for cameras. It's or the component which are present in that particular one, or any machineries, for that patent we can get. And whether it is on a living or on a non-living products or pharmaceutical products also, we can get on a patent. So as we can get on a patent for a pharmaceutical products, that's why that we are discussing now. Okay, or any composition of a matter or a pharmaceutical products, or any process, manner, or art of manufacturing other than essential biological process. For those, all those things, we can able to file a patent and we can able to get that patents. This is the most important things. Okay, so my product is on a novel product, and there is some inventive steps are there, and it will have some applications to common people or industries. Then I can go get for patents. Then in which case the patent cannot be granted, or which type of products I cannot get a patent. So what are all the inventions which are non-patentable? So that part we are going to discuss now. There is 3 major points. How I told for patentable invention, it should be a novel, and there should be a inventive steps, and there should be some industrial applications. Like that, for non-patentable invention also there are 3 criteria. What are all those 3 criteria means? The matter which are incapable of being the subject of a legal monopoly. So for those particular matters, we can't able to file a patent. So when an invention which are contrary to a natural laws. So for that, a simple example I will tell you. If anybody is telling that a particular machines will give 100% efficiency, it is not at all possible. It was not obeying that natural law. And some invention they are telling without input we can get an output. So when you are not giving any input, how you will get an output? So simple in our studies also. If you are not studying, you can't be able to write in the examinations. So input that what you are studying is an input, and output what you are producing in your examinations or what knowledge you are getting. That is the thing. So when there is an input only, we will get an output. Without input, when some inventions are telling output is coming, means it was against the natural law. Such type of things we can't be able to get a patents. And when the matters are excluded by a policy or a morality. So for examples, that atomic energy and a human cloning. And by means of a policy or morality, these human cloning and atomic energy, all those things are not accepted. Because of that, you can't be able to get a patent rights for these atomic energy and a human cloning. And when that some matters are protected by other forms of an IPR. So for example, in the index also I told about copyrights and trademarks. Okay, when for example that's a film song story. Okay, so that was protected by a copyright. We can't get a patent for that song or for that particular story. So any matters which are protected by other form of an IPR, we can't able to file a patent. So these are all the things are non-patentable. And the most important thing, that any invention which are falling under the section 3 and 4 of a patent of 1970, those things also we can't able to file a patent. And these section 3 and 4 elaborately we are going to discuss. And in the section 3 and 4, if you are looking, section 3 will have so many subdivisions. There are 16 subdivisions in the section 3. So that will be called as 3A, 3B, 3C, like that. Up to 3P, there is sections are there. Each sections for one particular areas it will cover. So if your inventions are falling under these any of the sections of a 3 and 4, or the subdivisions of a 3 and 4, then that particular product or a patent, process are non-patentable. According to the section 3A, anything obviously contrary to the well-established natural law. So that is the thing in the initial 3 criteria also we told it. When it is opposing the natural laws, we can't be able to get patents. A simple example is perpetual machines. So what is this perpetual motion machines means? It is a theoretical machines. So what they are telling means that machines can work infinitively without giving an energy source. Is it possible? Not. Even for example, nowadays so many advanced technologies are coming. Okay, so for example, simple thing what we are using in our day-to-day life, take a TV remotes. There we are giving the energy in the form of a battery. That's why the TV remotes are working. After some particular period, what will happen? The energy which was stored in the battery was lost. Then we need to replace the batteries. So we are giving that energy in that form. But these perpetual motions, what they are telling, without energy, that particular some machines are running continuous indefinitely. So that is against a natural law. So such type of things we can't able to file a patent. And according to the section 3B, so what this 3B is telling means that should be dangerous to human, animal or plant life or health or to the environment. Anything which affected these natural things, then for those things also the patent will not be granted or we can't able to file a patent. So for example, gambling machines or the device which can, by using that device we can break a house, or biological warfare materials, and the things which can be used for cloning. Okay, all these things cannot be patented according to the section 3B. So 3A is telling about natural laws, and 3B is telling about which are having morality to human, animal, plant, and natural source. Then 3C. We can't patent on any scientific principles or the discovery of any living or on a non-living substances. If people must know what is the difference between an invention and a discovery. If your thing is invented, you can get on a patent. But if it is undiscovered, you can't. Because discovery means we are disclosing something which was not seen before. That means what? Already it is there, but it was not seen. So that only we will call it as a discovery. So for discovery, we can't able to get on a patent. But if you are invented anything, then we can able to get on a patent. So what is invention? That I told you, discovery, which is nothing but disclosing something which are not seen before. Whereas invention will add human knowledge. We are using that human knowledge to make some new product or on a process. So that's why we can't able to get on a patent for some Archimedes principles. Okay, that one cannot be patented. But using that Archimedes principle, if you are making on some instrument, you can get on a product patent. As such, for a principle, you can't able to get on a patent. But by using that principle, if you are designing some new product, new machinery, for that machines, you can get on a patent. And like that, if you are find it out on if you are discovered on some microorganism or on some natural gases, some minerals, all those things, discovery, that particular word is there means there is no patent. If you are invented, then you can go for a patent. So for discovery products, we can't able to get a patent. So that was clearly explained under section 3C of a Patent Act 1970. And when you are discovering something which was already known substances, but in a new form. So for example, chloroquine is there. And the chloroquine now you are discovered in a chloroquine malate form, some ester forms, that's all. So can I go ahead for a patent for the chloroquine malate? Not. Because already the chloroquine was known. What I discovered is another salt form of a chloroquine. In that case, the patents are not granted. Okay, that is the thing. New form of a known substances, we will not get it. Or any discovery of a new property or a new use for a known substances. Already that particular substance was there. I find out that particular substance can be used for this particular purpose. That new use was not known. That one also non-patentable only. And that is the thing. Salt form, ester form, ether form, polymorphs, metabolites, particle size, isomers, or mixers of an isomers, complexes, or already some A drug is there, B drug is there. I found combined that A and B, and I formed a new formulations. That one, all those things cannot be patented. Okay, unlike that aspirins, the new use, we can use that one for what that that aspirin will come under the category of an NSAID only. But if you are looking nowadays, what that aspirin was used in heart diseases as a preventive purposes. Okay, that is a new use only, but we can't be able to protect with that pattern. Unlike that, in new uses of a neem, like that, any new uses of an already existing products, we can't go for a patent. And according to the section 3E, when a substance is obtaining by mixing an already existing two things, So, for example, all you people may aware of that paracetamol, which is an antipyretic agents, and Brufen, which is nothing but an diclofenac, where it is used as a painkiller, analgesic agents. That both the things are individually available. And when it combinations that I was mixed with an 500 mg of an paracetamol and an 10 mg of an diclofenac or ibuprofen, 200 mg of an ibuprofen, extra and I can make an drug, can I go for an patent? It is not. That according to the Patent Act, it was not patentable. And similarly, sugar is there, and in that sugar, if you are adding some colorants and if you are adding in a water and I made it as some new solutions, can I go get or on a drink? Can I go get for a patent? Means not. That is also according to the Patent Act, it was not possible. And according to the section 3F, when you are arranging or rearranging, or if you are duplicating known devices. Okay, so for example, in that, what is that? TV separately is there, watch is separately is there, light is there. I'm mixing all those things, or I'm arranging all those things in a different manner, and I'm making as only one product. Can I go get for patent for that particular product? Means no. That is the thing. So I was included on a timer in that watch and TV street light. Can I go get? Means the patent was not grounded. And 3G, okay, that is the section 3G for process of testing during manufactures. So earlier it was there, but nowadays in the year 2002 amendments, this section 3G was omitted. Process when we are using on something, the testing process, even that will also come under the category of a patentable one. On 3H, according to that section, any method of agriculture or horticulture is non-patentable. So, if you are finding any new method of agriculture or horticulture, can you able to protect that one with a patent act? Means it is not. And any process or medicine, surgical, curative, or therapeutic or other treatments of a human beings, not only for human beings, which was similarly applicable to all other animals also. So that process, medicinal process, cannot be patented. People can get some confusion in this 3I. So for that only I have given some elaborate examples for your easy understanding of section 3I. So process which can used to remove cancers, or the process by which we can use remove dental plaque and caries, or a surgical process, or any things which are related to the therapy or the method of your vaccinations cannot be patented. But if you are making some surgical or diagnostic apparatus or an instrument, okay, so that one is excluded from these non-patentable. Okay, surgical, therapeutic, or diagnostic apparatus or instruments are not excluded from the patentable. And we can't able to patent on any plant and an animal, either in a whole or in a part also. It includes on a microorganism also. And similarly, the process, biological process, by means of that particular process, if you are propagating some plant and animals, that one is not patentable. And simple examples are cloning and a new variety of plants. then microorganisms, and when you are doing a crossing, and if you are getting some new varieties, okay, and for example in the plant nowadays several crossing fruits and vegetables are coming, so we can't able to get a pattern for those such type of crossing, all those things. That is according to that section 3J. Similarly, we can't get a pattern for a mathematical or business method or a computer programs or algorithms. For these mathematical business methods and algorithms, that patent we can't able to get. And literary, hope my screen is visible.
Yes, sir.
Yes. So we can't get a pattern for any literary works or a dramatic work or a musical or artistic works, and these things can be covered by another form of IPRs. And you can't able to get a pattern for any rules or a method by which you can play the games. So simple example, if you want to tell means if you want to get a pattern for rules for a 2020 match rules, we can't get on a patterns. So any scheme or a rule by which we can play on a game. So for that we can't able to get on a patterns. And when you want to present on any informations, the way of presentations, if you want to get on a pattern means for that presentation of an informations also, the patterns are not granted. Similarly, for an integrated circuits, topography of an integrated circuits also, the patterns are not granted. And when you get on any invention which is due to a traditional knowledge, then for those invention also, it is not patentable. So, for example, say amla and neem. The properties of biological uses of these amla and neems are known. When you are getting some drying these amlas, and if you are powdering that one, and similarly neem also, if you are dried and make it as a powder and mixing, and if you want to get a pattern for that mixers, you will not get to that, because whatever that invention you made, it is due to the traditional knowledge only. So for those things, we can't able to get on a pattern. So this is about the 16 subcategories of section 3. That is on 3A to 3P. Then section 4, which was related to that atomic energy. According to that Act 1962, that anything or any invention which are related to the atomic energy is non-patentable only. Okay, I think hope you people can now have some idea about what is patent, what is IPR, and for what are all the products we can get on a patent, and what are all the products we can't able to get on a patent. And okay, if I'm getting on a patent, by that what I can do? If I'm having on a patent, what is the benefit? What are the features of these patents? That only we are going to discuss, salient features. It can be given to on a product as well as on a process. At present, that a patent will be granted for a period of 20 years. So the 20 years term that full rights are given to the inventor. And if you are requesting them to examine your invention, then only they will examine your invention. Unless you are requesting a patentee or controller, then they will not go or examine your invention and they will not grant a patent. Somebody is telling that so and so was novel, but you are telling no, before that I was that particular product or process was available, we are using for some other purpose, means you can oppose it. Any peoples can oppose. When you can oppose, before granting also you can oppose, or after granting also you can oppose. And there is a fast track mechanisms. So normal process, if it is taking on a 6 months, if you want to do it in a faster manner, there is a mechanisms, process are available in the Indian patent. And here there is a provisions are there to protect our biodiversity as well as on a traditional knowledge. So for that also they are taking care. And your applications will be published after 1.5 years of your filing applications. No, sir, 1.5 years I can't able to wait. Then there is another Tatkal schemes are there. Within a month also we can able to publish our invention. And because of that, we can able to complete all those things with a reduced timelines. What is the object of this patent? Like earlier, we the first slide itself we discussed there that it is an rights that what is that ideas are protected. Okay, so this patent will give you a statutory rights to the owner of that invention for a period of your time. That period of your time is 20 years. In the 20 years, he is the lone persons can use, sell or work on their invention. And they can use the things for a commercial purpose. No other peoples can use or sell without his permissions. With his permissions, they can use it. And because of that patent, whatever I invented, I am disclosing my invention to the scientific peoples. That I'm keeping my invention. Yes, this is the thing I invented and I'm keeping in a public forum. Anybody can look, but what? They cannot be used it for a commercial purpose. But what are the advantages is there? When it was kept in a commercial forum, because of that, we can get on a scientific knowledge. And that will be helpful for a future research. By using that particular thing, some other new invention will come. And by means of that patent act, what? We are passing our invention into the public domain. Something you are invented, and if you are keeping yourself, no use. When it is patented and automatically, if it is helpful for common peoples, that automatically it will come into the public domain. Because of that, you will get beneficial also. And that patent is on a very important source for scientific and technical literatures. And it is a treasure house for a scientific invention. There only new technologies, new methods, new process, all those things we can get it. And so, for example, one particular process. Recently, what is that? In the 2019 end, we faced on that whole world. We are in a pathetic situations because of that COVID-19. Okay, so that time that everybody what we people are when that vaccines will come or what medicines will come to protect from coronavirus. Okay, so many scientists are working in a same aim. Okay, when you are applying for a patent, so the other people will came to know, yes, for those things already the solution was there, then we can avoid duplications and it will give a way for further discoveries. Because of the patent we can stop the reinventing waves. Already if it is existing means everybody will know, yes, it was available, so then they will look for others. And if you have a more number of patent, automatically you will more people will come and collaborate you. If you have a product patent, many commercial companies will come and will ask you, yes, you will give a permission for us to use that particular process. We will give on a money, we will can keep it on a contracts like that. So you will get on a more collaborations, you will get on a money, and you will get on a fame, name, etc. Everything when you have on a patent. So when you have a more number of patent, all these things will more come. And in a scientific communities, that it will be more helpful. So patent rights, what it will do, the third party cannot be authorized to produce, use, for sale, for import or distributions and licensing. All these things are prevented if you have a patent. One product you had invented and no one, without your permission, no one can make, use, sell or import or distribute or license. So these rights are given to you by an Indian government for a period of 20 years. Then you think how much? One idea is enough. And there will be some safeguards. Okay, if it is like that, whatever that person who is having a patent, they can whatever that amount they are telling, that only will come. So for that also there is a safeguard given by a government in the patent laws. There will be a compulsory license to ensure the availability of your drugs at a reasonable prices. When there is an emergency, we should take care of that. There will be some provision is also available. And revocation of patent in case of interest of the public and also for security considerations. These are all the safeguards which are present in the patent laws. And generally there are different types of patents, but mostly these three only commonly called as types of patents. So ordinary patent and addition patent or convention patents. And when you are going for whether a product or a process, based on that also we can tell that one is a product patent or a process patent. In that all these three things will. Okay, we can ordinarily file a patent, or we can additionally file a patent, or conventionally we can file a patents. So now we know about basic things regarding to patents. What is patent? What are all the things can be patented? What are all the things cannot be patented? What are all the rights we can get when we have patents? Okay, so now I'm having an idea. Based on idea, now I produced I invented some product or a process. Okay, now I'm having that process or a product. How I can get, sir? How I can file a patent? So step by step, now we are going to discuss about what is the procedure we should follow to get a patent. So the first and foremost important thing is we should not disclose our invention to other peoples. Whenever we got an ideas, first make that ideas, write that particular ideas. Then from that idea, try to develop a product or a process. When you are going to develop a product or a process, keep in your mind how your ideas or your product is better than already existing one. Why your product is needed? Is it necessary? So already that product is available at a cost of 10 rupees. When your product is costing 100 rupees, what is the use? No use in that case. Okay, so if already available process or product is on 1,000 rupees, you are invented the same product by on a different process and the cost is coming only 100 rupees. In that case, there is a economic point. Okay, so why your invention is needed? Yes, my invention is needed because whatever that invention which are already existing is having that particular disadvantages. That all those disadvantages are covered or rectified by means of my invention. So you should ask yourself a question: why my invention is needed? Compared to the existing products, your new product is what novelty is there in your new product. Already if it is there, means what is the novelty? So that you should ask yourself. Then this is the 9 steps we should follow when we want to get on a patent. First, we should file an application. That is the first and foremost thing we should do. That is, if you want to get on a college seats, what first thing we should apply for that particular seats. So similarly, first you should file your applications. Then they will formally check your applications whether all things are written correctly or not. After formality check, within 18 months, your patent applications will be published in a common forum. There is a journal published by an Indian government that your idea was published. Then what? That can be seen by all over the world. Everybody can see what you are proposed. If you are copied anybody's ideas or already existing things, some people will oppose before granting itself. That is the thing. They can oppose any persons. Okay, no one is opposed there. After that, you can go good for examine your process or on a patent. Then if they are examining and they found that yes, really your product or on a process on a novel, they have an inventive steps and they have a commercial users, then they will grant. In case if it is not there, they will refuse. Once it granted, then after granting also there is a chance for oppositions. In that case, the controller will take on a decisions by seeing what purpose they are opposing. Is it real or not? Okay. Then finally, the controller will tell if he is satisfied with that answers which was given by granted peoples, then he will tell that patent was granted, or otherwise he will withdraw the patents. Elaborately, we can discuss one by one. Step 1, we need to file an applications. What will be there? Okay. Whose are? Can I directly go and file an applications? If I want to file an application, where should I go and file? And how I can file a patent application? These 3 things will come in our mind. Who, where, and how. Any individuals can able to file an applications. And we have to file that particular application in a patent office. And that patent office within the jurisdictions where it is available, there you have to go and file the applications with a prescribed fee. And the guidelines will be given, detailed guidelines will be given in that official website. That is the official website of an Indian Patent Office, ipindia.nic.in. There the details of fees, guidelines, everything was given clearly. According to the section 6 and 134, a patent can be filed individually or on a jointly also. 10 members, 12 members, 15 members combinedly can be filed on a patent. Yes, you can file it. It is not necessary only that only one person. Alone you can file or jointly you can file. And any persons who is the true or on a first inventor of that things, those persons can be eligible to file a patent. Or you can assign some persons. Okay, if you can't able to go, you can assign somebody else. He is the representative of me. Okay, so instead of me, he is filing a patent. Or if any deceased persons, in that case, a legal representative can file a patent. And where we have to file a patent? There is an head office as well as a branch office are available. Totally one head office and 3 branch office are available. In that particular case, in your what is that city or on things in which territorial limits it is coming, there you have to go or file that patents. It can be your native place or where you are doing on a business or that particular invention where it was originated. In these 3 things, anyone if it is coming, there you are eligible to file a patent. So these are all the 4 offices. Okay, so Chennai, Mumbai, New Delhi and Kolkata. So in these 4 cities, we have a patent office, and head office is in Kolkata only. The patent head office is in Kolkata. This Chennai, Mumbai and New Delhi are 3 branch office of a patent office. So these are all the territorial jurisdictions. They can contact that Chennai branch office. So Andhra Pradesh, Karnataka, Kerala, Tamil Nadu, Telangana and Pondicherry Union Pradesh and Lakshadweep all can able to file a patent in Chennai office. Similarly, these territorial jurisdiction in Mumbai and these territorial jurisdiction in New Delhi, and if anything is not covered in these things, the rest of India can directly file in a head office in Kolkata. And this is the postal address and their phone mobile numbers, fax and their email IDs, official email IDs of these each branch office and head office of that patent offices. So if I want to file on a patent, is it necessary to go to the patent office means? Nowadays, no. Before 2007, we should go directly only. After 2007, July 20, they introduced the electronic filing. That is nothing but e-filing. From the home, in front of computer, we can sit and we can file. Okay, and or otherwise, no, sir, I'm not interested in an online. Can I go with an offline? Yes, you can go. Or you can send it through a post also, or otherwise you can directly go and you can hand over the things. These are all the documents are needed when you are filing your application, patent applications. First thing, cover letter. That is not a simple thing. So that is the thing. So that is Dr. G. Saravanan. So Professor and HOD, MNR College of Pharmacies. 2, which patent office? And what is your subject? So that I was invented something, I need to apply a patent for my inventions. Like that, some simple covering letters. So there you should indicate what are all the documents you attached. What are all the forms you attached. All those things you should indicate. And with the specified amount of an fee, either check, DD, nowadays digital transactions is also available. By means of that, we need to pay or you need to apply, you need to file your applications. So these are all the major informations which will be present in different forms. The form number 1 it will include your name, address, contact details, and if you are assigning somebody, who is that assignee and what is its details, everything will be there in that form number 1. And in that form number 3, assignments and detail of foreign filing. If you already filed in any foreign countries, that details will be given in form 3. And when you want to request that Patent General to examine your invention, then you should use on a form number 18. And if you want to go for an yearly publication, you should use here form number 9. And if you want to give on a power of authority, then you need to use here form number 26. And this is the most important thing. Technical information will be given in number form 2. So form number 1 is personal information. Technical information will be given in another form number 2. So there only we should describe our invention. Why that particular inventions are needed. Okay, that is in a simple manner. If you want to tell aim, what is your aim? Because of that one, I went for this particular invention. And second thing, you should summarize your invention. How your inventions are working. What is the basic things which are involved in your invention? And with the examples, you have to summarize here. And finally, okay, so because of that, I done. This is my invention. From that, what are things you are claiming? This is the most important part. You can claim n number of things. Okay, whether it is dependent or independent. And you have to give abstracts also, where all these 3 things will covered in abstracts. So these are the details of various forms. Okay, from starting from number 1, if you are looking, there are 30 different forms are available. And this is the form number 1 photocopy. So there it will ask about your personal details. And what is your title of invention, and what is your name, and what is your address, communication address, contact number, everything will be asked in form number 1. That is 5 pages will be there in the form number 1. And form number 2, as I told you, this is specifications that will describe about your inventions. Okay, so the inventions will be described in form number 2. Then in specifications here, that is the things, form number 2. What are all the contents are there in the specifications? That form, it was not visible clearly. That's why I was separately written here. So you should provide your title of an invention, in which field your invention will come, and what is your background of your invention, what is your object of the invention, and you should summarize your process. And if any drawings are there, or you should explain your invention in brief drawings, and you should give a detailed description of inventions. And in case if it is on a provisional application, there is no need of giving claims. But if it is on a conventional, then you should give about claims. And in case of a provisional, no abstracts is also needed. So what is the provisional applications? Are complete specification. 2 things are there. Provisional and complete. The name itself is the complete. So here we are giving complete specification about our invention. And in case of a provisional, it will only describe about the nature of the invention only. And it will describe about the essential feature of invention. And there it is not necessary to mention our claims and an abstract. But fee is similar for provisional specifications. Sorry. The fee is similar for an provisional as well as an complete specification. Whether it is a provisional or an complete, the fee is similar only. But when you are filing as a provisional specifications, they will give only 1 year of your time only, 12 months only. Within a 12 months, you need to submit the complete specifications. If you are not submitting within 12 months, they will not consider. So in the complete specifications, what it will be there? Full description of an inventions will be there, and the best method of making invention will be mentioned in the complete specifications, and there will be a number of claims will be there, abstract, everything will be there in the complete specifications. After submitting a complete specifications only, they will go get for an publications. And before doing a complete specification, if you are mentioning on any biological material, that material should be submitted to the respective office. In India, it will be available in the Chandigarh Institute of Microbial Technology. There you have to submit your biological materials. And this is the Form 3 will be an undertaking form. And that is you are telling that that is my own invention, and you are declaring in the form number 5. And this is the form which can be used to tell that please publish my invention in a public forum. If you are not applying also, within 1.5 years, automatically it will come. When you need earlier means, then you have to go get in the Tatkal scheme. And this is the form number 18, which can be used that you are requesting that patent attorney general to go ahead with your invention. They will check your invention, they will examine, and they will tell you whether your inventions are novel or not. And if you are giving a power of attorney to some people, so then you have to use your form number 26. And this is the fees which was prescribed by an Indian Patent Office. If it is on a natural person, then the filing fee is on 1,000 rupees. Other than that natural person, that will be on 4,000 rupees. And when each seat, if it is not excluding 30, then in that case 100 rupees. And for an up to 10 client, 200 rupees. Then after that, the additional charges will be produced. Cognate filings. When we are filing on 2 or more applications, in that case, you can add that one application with another if it is for an same inventions. Okay, with respect of an invention, when it is on a cognate, that means nothing but it is on a modification of the already existing one. In that case, we can combine both the things and we can submit. So under section 9 of 3, we can convert the provisional applications within a 12 months to on a complete specifications. So this is the data what you will get, your names, inventor, country, what is their nationality, and what is their address. Okay, so this is an non-provisional applications what you will get. This is the title of invention. Okay, when you filed an applications, and your application number will come here. And this is the fee details, what you are paying to that intellectual property India when you are e-filing. And formality checks. Once you submitted your application, they formally will check, and immediately they will acknowledge that one, and they will allot a application number. And usually if it is an online, immediately it will generate. When you are applying through on a post, within on a 2 to 3 days, they will send you on a application numbers. And publication, I told 1.5 years. Okay, or if you want to publish immediately also through on a Tatkal scheme, you can use these publication steps very fastly. That is the thing. Request for yearly publications according to the rule 22A. Okay, so for yearly publication, you need to pay 2,500 rupees. and pre-grant oppositions. So once it was published, that will come into a public forum. Everybody will look, and when somebody is looking, what the persons who is claiming it is on a novel is actually on a novel one, and that was already done by us, or it was already existing in that case. Okay, they will oppose you. Okay, so whatever the mentioned is not on a new one, and they will write a opposition to on a controller. Then the controller will give a notification to that particular person who filed the patent. He has to give clarifications. Okay, either by means of writing, or sometimes there will be a face-to-face interactions will also be there if it is needed. In that case, they are finding which one is correct. If whoever is opposing, if it is wrong, then automatically the process will be continued. Otherwise, they will stop.
అది ఓపెన్ చేయాలి కదా సిస్టమ్ కి ఇప్పుడు స్విచ్ బోర్డ్స్ అన్ని చూసుకొని పోయినారు కదా.
So when you want to examine, you need to give a request to the patent attorney generals. When you are not requesting, no grant will be produced. Okay. From the filing 4 years, that is 40 will come, and that time you have to request them. Please examine my invention. For that, again, a fees is on a 2,500 rupees.
Okay, మొత్తం date right.
So when your invention is novel, and if the attorney general is satisfied, then they will grant. In case they are finding yours is not novel, then they will not grant your patent. Once it was granted, then can anybody object? Yes, there will be a post-grant opposition is also there. And once it was granted, then it will be published in the official journal of Indian Patent Office, and a certificate will be issued within 7 days. So this is the patent grant certificates. So there it will come your patent number and your application number when you file your invent, and which person is getting on a patent, and the description about that particular patents, and with the signature of that Controller General of your patent, you will get it. When it was granted, the date will also be mentioned. Okay, so you need to renew your patent year wise. So they will tell about the date which year you need to renew. That will also mention in your patent grant certificate itself. That's the post grant. After granting also, we can able to oppose, and again in the time also, if they are founding, if it is not novel, then the time also will cancel your patent. And finally, the decision is taken by a controller who can have a rights to withdraw a grant of a patent at any point of time. This is the fee schedules, and this is a renewal fees for a patent. Okay, from that to 60 year, 500 rupees you need to pay, or individually. Then only your patent will be live. And 7th to 10th year, you should pay 1,500. And 11th to 15th year, when years are increasing, the renewal fee will increase. If it is 16th to 20th year, 500 rupees, 5,000 rupees you need to pay for it. You can file an international applications also, and there will be an receiving officers will be there for an international applications, or you can directly file your applications in the international group Geneva through an online house. So this is a simple representation. Prior to 2005, if you are applying, they will examine. That means they will check your things, and if it is okay, they will grant your things. After that, they will advertise in advertisement of an acceptance or complete specifications will be published, then anybody is opposing, then they will seal or grant that patent. But from 2005 onwards, first we need to file our applications. Once you are filed, and within 18 months they will publish. If we want the earlier publications, we can go there. And in that case, there will be an before granting, somebody is subject means they can oppose, or nobody is opposing. And if we are giving an request, the patent general will go for examinations, and from that, if they are satisfied, you will get an grant applications. Or after that grant also, they can oppose. That is on a post grant approach. So this is on a simple graphical representations by which we can able to see the step-by-step filing of an patents. This is on a detailed graphical representations. So once you got an ideas, okay, based on that idea, you invented something, then you need to file your applications. Okay, so first I need some 6 months time to make that my invention into a clear one. So in that case, I can go for a provisional specifications. When you are so I think hope I'm audible and my screen is visible.
Yes, sir. Yes, sir. Yes, sir. Please carry on.
So after provisional applications, I will get on a 12 months of period of your time. Then I can file a complete application, or directly I can file a complete application also. Then from that, I can able to go for an applications. There I will have an 18 months of a time. After that, when I am requesting for the examinations, they will examine and they will give on a first examination reports. Based on that reports, so if I'm clarifying everything, then they will grant a patents. So during that time, post grant or pre grant, anybody can object, or otherwise the patent will be abandoned. Okay. Yes, I think with this I will complete my presentations. So these are all the references, and you can get all these details in an official website of an intellectual property India. Any queries? You can ask.
Hello, sir.
Thank you, sir, for your.
Hello, sir.
Sendil, it's audible, Sendil.
Thank you, sir, for your valuable talk about Indian patent and overview. So, students, if you have any queries or any clarifications about Indian patent, so can you discuss with our resource persons? Please raise your hands. Mic will come to you. Any doubts, any query, or any clarifications with you? No. Third year? Fourth year people? Nobody? Okay. I think maybe you got it all the information. Yes, sir. Thank you. Thank you.
There is another two things, Sendil. Actually, if they understand all the things, they may not get on a doubts. Or another thing, if they are not understanding anything also, they will not get on a doubts. I think which one I can take? Understand or not understand? Students?
Sir, they have understand everything from your talk. Because we are Sri Shanmugha College of Pharmacy students. And Pharma, I want to thank formally. So, sir, thank you for your valuable talk about Indian pattern and overview. And you have spent more than 2 hours with us. And you have discussed about Indian IPR, intellectual property rights. Please keep quiet. On Indian pattern and the history of the Indian pattern, and also discussed role of the pattern and how to get the pattern and why we have to get the patterns. And also we have discussed with our students about selling futures and important under patterns. And we have discussed with our students about how to file the patent and all the information. It is valuable for us. So might be our students will be while doing the projects, maybe they will file their projects for individual patents. So thank you so much, sir, for your valuable talk. Thank you, sir.
Yes, thank you, Sindhu.
Now, I would like to invite Dr. C. Senthil Kumar Sir, Professor and HOD, Department of Pharmaceutics of Sri Shanmugha College of Pharmacy, to give the vote of thanks for this program.
Thank you. Please go ahead. So now it is the right time to give the vote of thanks for the webinar on Indian patent and overview. On 9th June 2023, organized by Institutions Innovation Council, Sri Shanmugha College of Pharmacy, Salem, Tamil Nadu. We want to thank our Honorable Chairman, Mr. K. Shanmugha. Keep quiet. K. Shanmugam, Sri Shanmugha Educational Institution, sir. Sir has accepted our request and initiative to conduct this kind of webinar in our esteemed institution. Thank you very much, sir, for your support. We want to thank our Honorable Executive Director, Mr. A. Tirumurthy, Sri Shanmugha Education Institution. Sir has accepted our invitation and motivated us to conduct this kind of program. Thank you very much, sir, for your valuable support in all the way. We want to thank our Joint Secretary, Mrs. Kogila, Sri Shanmugha Education Institutions. Thank you, madam. Thank you, madam, for your support for the entire program to conduct in a successful manner. We want to thank our advisor, Dr. Srinivasan, Sri Shanmugha Education Institution. Thank you, sir, for your guidance and support for this entire program. Thank you very much, sir. We want to thank our principal, Dr.N.Balakrishnan, Sri Shanmugha College of Pharmacy, given welcome address for this webinar and initiated us to conduct the webinar by Institutions Innovation Councils. Sir has taken a lot of effort to conduct this program in a grand manner and given valuable suggestion to execute this program. Without his support, we can't move forward. Thank you very much, sir, for your constant support and need your support in future also. Thank you, sir. We want to thank our Vice Principal, Dr. G. Ratanavel, Sri Shanmugha College of Pharmacy. Thank you, sir, for your support for this webinar. Thank you very much. I thank IIC Convenor, Dr.R.Prema, Department of Pharmaceutics, Sri Shanmugha College of Pharmacy, has planned and organized to execute the grand success of this program and give the talk on about resource persons. Thank you, madam. We express our gratitude to resource person, Dr. G. Saravanan, Professor and HOD, Department of Pharmaceutical Chemistry, MNR College of Pharmacy, Sangareddy, Telangana, for accepting our invitation and giving a wonderful talk on Indian pattern and overview. Thank you very much, sir. We thank all the HOD of various departments of Sri Shanmugha College of Pharmacy and all the committee members of Institutions Innovation Council, Sri Shanmugha College of Pharmacy, and teaching and non-teaching staff of Sri Shanmugha College of Pharmacy for your support entire this program. Thank you all. We want to thank HR Department, Maintenance and Admin Executive Staff of Sri Shanmugha Education Institutions and students who volunteers of Sri Shanmugha College of Pharmacy. Our special thanks to our 4th year and 3rd year Pharm students for attending the webinar and have spent more than 2 hours with us. Thank you. Unknowingly, if I left thanking anybody, your support will always be remembered. Thank you, one and all. Thank you very much.
Sir, thank you, sir.
Thank you, Sandil.
Thank you, sir. Thank you so much for your. I will call you, sir. Thank you.
Okay.
Yes, sir.
Sir, program 19 webinar. Shall we end?
Yes.
Dear students, I think maybe you have